case briefs, and so much more. LSData's got what you're looking for.
A 1939 legal case, Sierocinski vs. E.I. du Pont De Nemours and Company, revolved around a man who filed a lawsuit against a company for alleged negligence in the manufacturing and distributing of a dynamite cap that prematurely exploded and injured him. The company argued that the plaintiff's complaint lacked specifics about the type of claim being made, and the lower court sided with the company, dismissing the case. However, the man decided to appeal, arguing that the company was liable for the injuries caused by a defectively manufactured article. The United States Court of Appeals for the Third Circuit heard the case, focusing on the clarity required for a complaint in order for the defendant to know how to defend themselves. The appellate court concluded that the plaintiff's claim was sufficient, and that the company was on notice of the specific allegation of negligent manufacture and distribution of the cap. The case was then remanded for further proceedings. In reversing the lower court's judgment, the appellate court held that the man's complaint met the federal rules of civil procedure requirements, providing sufficient information to determine the claim type. The court also emphasized that evidence was not necessary and cited Form 9 as an example of the leniency in pleading.
Case briefs, and so much more. LSData's got what you're looking for. Visit LSD.law, elevate your mind. Leave the stress of class.